Welcome. If you are getting ready for the SQE1, misrepresentation is one of those topics you have got to know inside and out. In this explainer, we're going to give you a really clear step-by-step framework to get your head around the rules, the key cases, and exactly how to apply them. So let's jump right in.
This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
Look, we've all been there, haven't we? Someone promises you one thing before you buy something, and then you discover the reality is, well, completely different. So what can you actually do about it? Well, contract law has a very specific tool designed to police those really important statements made before you ever sign on the dotted line. Okay, so this is the core legal definition you need to have locked in your brain. An actionable misrepresentation is an unambiguous, false statement of fact which induces the claimant to enter into the contract. Those four parts, unambiguous, false, fact, and induces, are the absolute building blocks. Let's break down what each one really means. To win a claim, it's not enough to just feel like you were misled. The law is super precise here. You have to prove 5 distinct elements. The best way to think about it is like a legal checklist. If you miss just one, the whole claim can fall apart. So first things first. Unambiguous just means the statement has to be clear enough for a reasonable person to understand it. False means it has to be incorrect in a meaningful way, and crucially, it must be a statement of fact. Now, this last one is a classic exam trap, so let's take a closer look. Okay, so let's get really precise here. The law separates facts from 2 other kinds of statements. First, you've got what's called sales puff. You know, those vague, over-the-top claims like, "This is the best coffee in London." No reasonable person takes that literally. Then there are statements of opinion, like, "I believe this business will do very well." Generally, neither puff nor opinion can be a misrepresentation, but, and this is a big but, the law on opinion has a really critical exception. And this is that exception. It comes from the classic case Smith v. Land and House Property Corporation. In that case, the seller of a hotel called its tenant most desirable, even though he knew the tenant was seriously behind on rent. The court said, look, because the seller was in a position to know the real facts, his opinion was actually an implied statement of fact. The principle is this. An opinion coming from someone with special knowledge or expertise can be treated by the law as a statement of fact. Now for the final 2 elements on our checklist. First, the statement has to be addressed to the claimant. Pretty straightforward. It means it was made to the person who's now bringing the claim. And second, it must have induced the contract. This is all about causation. The statement doesn't have to be the only reason they signed, but it has to be a real and substantial factor that pushed them over the line. So, once you've ticked off all 5 of those elements, you've officially established an actionable misrepresentation. But you're not done yet. The next crucial step is to figure out which type of misrepresentation it is. This is absolutely vital because the category it falls into determines what you can get out of it. The category depends entirely on the state of mind of the person who made the statement. You have to ask, were they being deliberately dishonest? Were they just being careless? Or was it a genuine, honest mistake? The answer to that question will put the claim into one of 3 very distinct boxes. Here they are, the 3 types. First up is fraudulent, which was defined in the case of Derry v. Peak. This is the most serious one. It's basically a lie, made knowingly or just recklessly, not caring if it's true or false. Second is negligent misrepresentation, which comes from the Misrepresentation Act 1967. This is for careless statements. And here's a crucial point for your exam. The burden of proof flips. Once the claimant shows the statement was false, it's on the person who said it to prove they had good reason to believe it was true. This makes it a really powerful claim. And finally, you have innocent misrepresentation. This is for an honest mistake, where the person genuinely had reasonable grounds to believe what they were saying Okay, so why does it matter so much which of those three boxes you put the misrepresentation in? Well, because it unlocks the legal toolbox of remedies. What can the wronged party actually get? Let's take a look. The two main remedies are rescission and damages. The easiest way to think of rescission is as a legal time machine. It unwinds the whole deal and tries to put everyone back where they were before the contract ever happened. That one is available for all three types. Damages, on the other hand, are simpler. It's money. It's financial compensation for the losses you've suffered. But whether you can get damages and how much depends entirely on whether the misrepresentation was fraudulent, negligent, or innocent.
But hang on a second. That legal time machine, rescission, isn't always an option. The right to unwind the contract can actually be lost. The law has set out 4 key situations, often called the bars to rescission, that will completely block this remedy.
First up is affirmation. This is where you find out about the lie, but you decide to carry on with the contract anyway. You can't change your mind later. Second, lapse of time. You simply wait too long to do anything about it. Third, if restitution is impossible. For example, you can't return a cake you were tricked into buying because you've already eaten it. And finally, if an innocent third party now has rights over the property, the court won't step in and take it away from them. You absolutely have to know these 4 bars for the exam.
All right, we've covered a lot of theory. Now let's see how you apply it, because that is what the SQE is all about. Here is a typical scenario you might face. Okay, let's really pull this apart. Notice the timeline, it's everything here. The owner makes a statement in January that, as far as he knows, is true. But in March, something huge changes. He finds out it's actually false. He then says nothing and lets the buyer go ahead and purchase the painting in April. The key legal issue here is his silence. So, what do you think? What is the buyer's strongest possible claim? Take a second, think back through the 3 types we discussed. Really focus on the gallery owner's state of mind in April when the contract was actually made. Go ahead and pause here if you want to work it out. The correct answer is a claim for fraudulent misrepresentation. Why? Well, this scenario is a textbook example of the principle from the case With v. O'Flanagan. The rule is that if you make a statement that's true at the time, but it becomes false before the contract is signed, you have a duty to correct it. By finding out the truth in March and then knowingly staying silent, the owner's silence became a deliberate lie. It's not innocent, it's not careless, it is deceit, and that is fraud. Phew, that was a lot to get through, but you've got this. To help all of this stick for your revision, let's do a really quick rapid-fire recap of the absolute must-know points. Here are your key takeaways. Master this list. Know those 5 essential elements. Remember the change of circumstances rule. Understand the difference between fact and opinion, and the expert exception. Memorize the 3 types and the key cases for each. And finally, don't ever forget those 4 bars to rescission. This is your core knowledge for the exam. And to leave you with one last thing to think about, this whole area of law is really a balancing act. On one side, the law wants to protect people from being tricked. But on the other, there's that ancient principle of caveat emptor, which basically means let the buyer beware. Think about how the rules we've just discussed try to strike a fair balance between those 2 powerful ideas. Thanks for joining me.